truly a privilege to educate our next generation of lawyers in what's an absolutely critical topic. I've been in practice for 19 years, and more important than my practice, I'm a mom to 5 kids, 2 amazing dogs who you may very well see at some point if we get a Zoom bomb, as often happens. I'm delighted to talk with you about one of the most important aspects of my practice. I'm a special needs attorney, and that falls under the umbrella of trusts and estates. So the documents we handle in trusts and estates are affected by special needs, and all of them are crucial. This seminar is going to focus on tools in the capacity planning toolkit, which is a really fancy way of saying once a child turns 18, how do we make sure they're provided for? Now, there's a common misconception that special needs is anybody can do it, it's really simple, and it's a sliver of the law. That could not be more incorrect. The breadth and depth of special needs is so deep and so vast and so wide. We have subspecialties within it. So we're going to focus on a sliver of a sliver, those capacity planning tools, powers of attorney or guardianship. And they run a spectrum, and we're going to talk about it in high level. Everything that I share with you is going to be based on personal experience with clients. And I highly encourage you, if you have a question at the end, please ask. If you'd like resources, please ask. And hopefully this will spur you to talk with your own attorney about things that I may have raised you may not have thought of. Now, while our relationship today doesn't establish an attorney-client relationship, I'm here to help, and I'm here to provide resources and start conversations. So let's talk about what capacity is. Capacity is, and of course, Virginia, the Commonwealth that makes things as difficult as possible. And I do truly believe that most of our delegates are lawyers. They're worried about job security. We make things really, really complex. We'll have clients ask us to reduce the power of attorney to a one-page, completely readable document. It can't be done, but we can explain what it is in a completely understandable way. But we have to start with an understanding of what capacity is. Now, the definition of legal capacity and medical capacity are different. With medical capacity, we're talking about informed consent. Now, that can shimmy over to the legal world, and we're going to talk about that in the context of guardianship. But when I'm talking about legal capacity, I'm talking about the ability to execute legal documents by having an understanding of what they require. Now, it's really important to note that once an individual turns 18, they are presumed to be legally capacitated. You could have an 18-year-old who is in a persistent vegetative state, and the second that birthday happens, they're legally presumed to be capacitated. That doesn't change until somebody in a black robe signs an order. Now, legal capacity has a range because each document we're going to talk about when it comes to decision making has its own standard. So not only are legal and medical capacity different, we have different standards of capacity for the documents we're talking about. Now, we're going to limit today to powers of attorney and guardianship. Those are decision-making tools in our capacity toolkit. Powers of attorney are documents an attorney would draft on behalf of a client. The client would then execute. Guardianship is a proceeding that happens in the circuit court of the county where an alleged incapacitated individual lives. Neither of these things are automatic. They require some interaction with the legal system. So when we turn 18, we have a presumption of legal capacity. Now, once that presumption of legal capacity is present, we have to remember who is the client, who is the person we're advocating for. I'll get calls all day long from family members who say, my son Johnny just turned 18. I'd like you to draft powers of attorney for him. Here's what I'd like them to say. When can he come in and sign? I can't do that. I need to talk to Johnny. I need to meet Johnny. I need to assess capacity for myself. I need to make sure Johnny can retain me as his attorney to draft these documents. And while mom and dad can be present for some of the meetings, they can't be present for all of them, particularly not the signing meeting where the documents are actually executed, because we have to be sure this is what Johnny wants, because the act of retaining an attorney requires capacity. The standard we're going to talk about the most, and it's because it's so high, is the standard of contractual capacity. Powers of attorney, the act of hiring an attorney, require the ability to contract. In layman's terms, I tell folks somebody has to be able to walk into a car dealership and purchase a car without being taken advantage of. Now, it's a pretty high standard, and we can reduce that standard to something understandable. Johnny, my name is Jen Crane. I'm a lawyer. Your parents brought you to me because they want you to have some documents that will allow them to continue helping the way they did prior to your turning 18. Pretty understandable, but it still addresses the standard of capacity. And we have to talk through what that standard of capacity requires. Because if we can't establish capacity to hire comes first. Next, there's the capacity to sign the documents. We might be in the gray area between powers of attorney and guardianship. So let's assume the standard of capacity is there. Johnny, a generic name for all 18-year-olds, comes in, affirms he wants to meet with me. Well, one of the first things we're going to do is we are going to ask for a capacity evaluation from the doctor who knows Johnny best. Now, you're saying to yourself, Jen, you just told us the medical standard of capacity is different from the legal. Why would we need a standard of capacity or a physician statement on capacity? Well, we're talking about tools in the planning toolkit for individuals with special needs. And as heartbreaking as it is to me in 2025, we know there are still a lot of stigmas that shouldn't be present. There's a lot of attorneys who automatically assume your child has a special need, you need guardianship. They won't even engage in the conversation about a power of attorney. But let's assume you're meeting with an attorney similar to myself who wants to start from the premise, yes, everybody's capacitated. And we've established that, yes, we think Johnny can have this meeting. Well, I know that Johnny's powers of attorney, once they are actually being used, because we have to remember, power of attorney is only as good as its acceptance rate. Having it as one thing, being able to use it effectively is another. And, at the end, one of the things I'd love to hear from you about is, have you used powers of attorney? What challenges have you run into? We see challenges all the time. First thing that happens when a power of attorney is challenged is the client comes back to the lawyer, says the power of attorney isn't being accepted. So one of the things I do in advance is I get a doctor's certification of capacity. And I have that for a couple reasons. Number one, I want to make sure that my assessment and the medical provider's assessment are in the same realm, because we all need legal and medical assistance, and it's important we work on collaboration. But even more than that, if a power of attorney is challenged in Virginia under the Uniform Power of Attorney Act, your friendly neighborhood attorney, the one who supervised the execution of the document, can prepare an affidavit. So let's say we are going to use a duly authorized, valid power of attorney at Bank of America. Bank of America refuses to accept it. Client comes back to lawyer and says, lawyer, you told me that if the power of attorney were ever challenged, I should just come straight to you and you would help me with it. Correct. Under the Uniform Power of Attorney Act, I'm going to exercise my authority as the attorney for the family to do an attorney's certification. where I vouch for the power of attorney and I affirm Johnny was capacitated when he signed it. And I know that because I've got it in my file. I'm going to confirm that to the best of my knowledge, information, and belief, the power of attorney has not been revoked, that it is still in full force and effect. And then I'm going to do what Bank of America wanted in the first place. I am going to vouch for it with my bar license and my malpractice coverage. That if there's a problem, the bank can turn around and say, we relied on Jen Crane. She told us we could accept this as a good power of attorney. And then if Bank of America or whoever it is, just an example, refuses to accept it, I can take that entity to court. And that's usually when I remind them, regardless of whether or not I win, you're going to be responsible for my legal fees. I bill at $500 an hour. What address should I have on file for you? That generally shakes loose whatever hesitations they may have had about accepting it. But I, as the lawyer, can't do that certification, and I won't unless all of those things are lined up. So it's got to be my client, and I have to have the capacity evaluation in the file. So all of this planning for use of the power of attorney starts before we've even signed. So we establish that Johnny can understand why he's retaining me and what the purpose is. I've met with Johnny enough alone, and he's able to explain to me in his own words why he wants mom and dad to continue helping him. And then we move to actually signing the document. Now, that standard of capacity is a high one, and it's really important to address the fact that you don't need to use an attorney to get these. Anybody can run out powers of attorney by getting on LegalZoom. Probably have ChatGPT write you one for free. But it's not going to have all of those necessary provisions. And it may not have an attorney standing behind it willing to go to war for it if it's not accepted. Because again, that power of attorney is only as effective as its acceptance. So we've got capacity, we've got the lawyer has everything they need to be able to support it when the time comes. Johnny understands it. Now we're going to talk about financial and medical, because you need two powers of attorney and you want to have two distinct ones that handle those issues. Now, the financial one, for as high as that standard of capacity is a bit easier to explain because we talk about banking, taxes, bills, things that parents have been helping with anyway. And it's a lot more relatable. The medical power of attorney it's a challenge because we're talking about real big things. And again, it's a conversation that really needs to be had at least once, only between me and Johnny. And we have to talk through big things like life support, terminal illness, persistent vegetative state. Now, it's important to remember that the power of attorney, particularly for medical, doesn't have to do everything. What do I mean by that? If organ donation is something the client can't comprehend, doesn't want to talk about, we don't have to put that power in there. The most important provision is the granting of authority to an agent to make medical decisions. We can do that by tailoring the document to what the client is or is not comfortable with. So we may have clients who come in and know they have a rare neurological disorder and they want to donate their body to science. Okay, we're going to tailor your medical power of attorney to authorize that, but we don't have to do it with every single client. It's really important that we are meeting clients where they are at and working with them at their level. If we do all of these things in advance, it establishes a relationship where the client is part of it, and they have to be. The two biggest issues we run into as lawyers are parents wanting to do the documents for the child and just running out the documents online. If these are going to work, they've got to be crafted with the client. And again, it gets back to the standard of capacity and why we put so much work in ahead of time to make sure it's there. because a financial and medical power of attorney are easier than getting guardianship. There is no court proceeding required. It's limited entirely to the interaction inside the attorney's office. And for the most part, the child, your child, is going to have the same providers they had prior to turning 18. So it's not going to be that big of an adjustment for them to exist with the powers of attorney. Now, some will probably start telling you as that 18th birthday nears, oh, we're not going to be able to let you in the room anymore, or Johnny's going to have to start signing things himself. It's really important to note that powers of attorney can't be done prior to age 18 because 18 is the age of majority. Prior to that, individuals are considered legally disabled by virtue or legally incapacitated by virtue of age. So we can have some talks about what powers of attorney are, but the capacity evaluation, the appointment, the signing, none of that can happen before an individual turns 18. Now, my guess is some of you are saying, but Jen, in Virginia, I know I can get guardianship at 17 and a half. That's because it's guardianship. So not all the ages correlate. So as our loved ones turn 18 or turn 17, we want to start thinking about which path we're going to take. If we're going to advocate for powers of attorney, we have to be honest about what Johnny can do. Can Johnny have these interactions? Is Johnny going to be able to explain what he can do, what he's comfortable with, so that the document is truly a manifestation of his intent? Powers of attorney have been around since Old English common law, and it's a structure where a principal gives to an agent the authority to act on their behalf. That authority isn't worth anything if the principal doesn't understand what they're doing. Anybody can run these things out online. It doesn't mean it's going to be the most effective tool for advocacy if it's not tailored to what the client can do. We run into problems with powers of attorney across the board, even for neurotypical families, but particularly for neurodivergent individuals, where there will be an automatic discriminatory intent or prejudice that because you have this condition, because you're on the spectrum, there's no way you could understand this. I'm not going to accept it. We will go to war over those powers of attorney when we know and are confident the individual is capacitated. But flip it. We'll have somebody bring a client in for special needs planning and they give us a power of attorney. Now it's signed and Johnny's executed it. I had nothing to do with it. But I know Johnny doesn't have capacity. I have to tell the family, your power of attorney on its face is legally valid. I can't accept it because I know he didn't understand what he was signing. And then the family will say, well, how do you know that? And I'll say, well, about 17 minutes ago, he told me Johnny will sign whatever you put in front of him. It's really important we use the right tool and it's tailored for what the individual needs. And that's why we assess it the entire way through. And that's why this toolkit is largely gray, because the answer is different for everybody. So we approach 18 and we start with the premise of powers of attorney, because everybody is presumed legally capacitated. Now, if you decide to go the power of attorney route, as I mentioned, it's a high bar to clear. It's important to talk with your child's medical provider in advance to ask what their thoughts are. Even more important if your child has mental health diagnoses, because we have a different power of attorney for that. We have our financial power of attorney, we have our medical power of attorney, and as an offshoot of our medical power of attorney, we have our psychiatric power of attorney. And that has an additional hurdle to clear. So everybody's got to be capacitated when they sign. They have to understand what it is they're signing. We have a bunch of formalities we have to meet. If there are existing psychiatric conditions, on top of this, we need to have an addendum signed by your child's medical provider that your child understood what they were signing, that they had the ability to give informed consent at the time they signed it. Why? Well, psychiatric power of attorney is a really big deal. So it used to be in Virginia that if you had a medical condition, let's go with bipolar 2, you came off your meds and you were making decisions you would not have made but for the episode you were experiencing. Only a judge could issue a TRO to have you held against your will or admitted for treatment against your will. Psychiatric powers of attorney give that authority to your agent. So an individual can vest their agent with the authority to admit them for treatment over their protest for a period not to exceed 10 days. Now, it's 10 days because that's typically the amount of time an individual needs to be medicated in order for the episode to diminish and then take their treatment back over. At the end of 10 days, if the person is still protesting the treatment, it does go to a judge, and that's to protect an individual's due process rights. But the psychiatric power of attorney, when used appropriately, can bypass the need for a TRO. And if any of you have ever been through one, they're horrific, and you lose a lot of control in the process. So we want to use the psychiatric POA where we can. Really specific requirements for execution and just one more level. So if you decide to embark down this route, everybody needs decision making. Everybody on the Zoom call over the age of 18 should have decision making documents, powers of attorney or guardianship. So as we approach 18, when that parental authority will automatically end, we start asking, powers of attorney or guardianship. Powers of attorney are going to be for individuals who can understand what they're signing, who can meet the contractual level of, they've got to have that ability to enter into a contract. They have to know what they're signing and be comfortable with it. They've got to be able to discuss it with the attorney without mom or dad present. The attorney, if they're doing all their due diligence, should get that capacity evaluation. Sometimes we get it ahead of time. Sometimes we get it before we've even met, and I'll talk about that in a second. But we've got that file papered, we have all the information necessary, and we make sure each of the documents is tailored to what the client wants and what the client can do. It's a really common scenario where clients come to meet with me. They've got existing documents. I review them and I say, did you know your power of attorney did XYZ? And they'll say, I had no idea it did that because the attorney never told me. We can't allow that ever, but particularly with special needs. We have to tailor the document to what the client can understand and is comfortable with. That's true for your financial and your medical. I want to spend a second talking about the medical. You know, the financial is exactly what it sounds like. Money, taxes, banks, entering into a contract for care. For the medical, it's really important. It does three things. It has to name agents, it has to give those agents powers, and it has to have an advanced medical directive, living will. That's the part that says, don't keep me alive in the event that I'm dying. Now, it doesn't have to. We can tailor it. We can make a medical power of attorney that's just the authority to engage in medical care. If a child can't understand the concept of the living will, or it's too upsetting to think about it, we can take it out. We have a lot of flexibility to do it, but it's important to make sure the document does all the things it can. Last but not least, really important, that medical power of attorney have a HIPAA authority. Now, very, very briefly, because this isn't relevant to most of what we're talking about, but I want to mention it. Powers of attorney can be basic or springing. A basic power of attorney means it's effective the second you sign it. So my power of attorney and my husband's are basic. So I can act for Matt right away. Matt can act for me right away. Springing, like a bunny springs, require doctors' certifications of incapacity before your agent's allowed to act. Now, for the most part, I don't love springing powers of attorney. We use them very, very sparsely because you need to trust the person who's acting for you. And if you don't trust them, such that you want that barrier, they could only act if you're incapacitated, we need to rethink who you're naming. But most medical powers of attorney are pre-programmed to be springing. This really matters if there's a HIPAA authority inside. If there's a HIPAA authority inside a springing medical power of attorney, you're not going to be able to get medical records unless the individual is legally is found to be incapacitated by two doctors. It's something that if you do run forms out online, you won't know unless I'm telling you. So I'm letting you know that HIPAA authority should always be immediately effective. It very frequently gets buried in there, and it's one of the ones that's most necessary. So your financial, your medical, and where necessary, the psychiatric power of attorney. Now, the psych POA is a really big deal, not something to be entered into lightly, and must be done with Johnny's full consent and understanding. Giving somebody the authority to treat you over your protest is a big deal. And at first blush, it feels like a voluntary abdication of autonomy. When we explain it's that or a magistrate, and most magistrates aren't as familiar with mental health crises as one would hope. Most times when we explain that, and we explain that after 10 days, if you are still protesting the treatment, it's going to revert to the judicial system anyway. Most individuals are going to opt for it. It's the best way to retain control because with a TRO or a TDO, we lose control and everything gets back to control. It's the only thing we can give throughout this process. So, got your powers of attorney, and we automatically kind of move to that as our planning technique when we can give enough signals to the attorney. The person, Johnny, is going to understand what we're doing and why we're doing it. Now, let's say we don't know, because oftentimes we get that call. Johnny's turning 18, and I think I should do powers of attorney. Maybe we should do guardianship. I don't know. I don't ever want anybody jumping to that decision one way or the other. If we are in the gray area where most of my life exists, we'll do the capacity evaluation ahead of time. And I'll take my cues from the doctor. So if Johnny's has a neuropsych, which is the dream scenario, because they're obviously the best capacity assessors, no offense to any other medical professionals on the call, I want somebody who knows Johnny best. I'll take the pediatrician. I'll take anybody who sees him regularly. When it comes to the capacity evaluation, I do prefer the highest level of medical degree. Can take it from a nurse practitioner. Generally do want it at some form of MD, PhD. We get the capacity evaluation because it's going to give me a signal. If the provider who knows Johnny best, who has spent his life treating Johnny, says, Johnny can't give informed consent for medical procedures, I don't think Johnny's got the capacity to enter into the document. Well, the doctor and I are going to talk through what the legal capacity is because most doctors don't know that piece either. So when we walk it through, we can come back to the family with a little bit of information on which path to take. Now, me as the lawyer, I have to be really, really careful when we're in the gray area because of conflict of interest rules. If you call me and say, Jen, or any other elder law special needs attorney, Jen, Johnny's turning 18. We don't know which path to take. We want to bring Johnny in to meet with you. I'm going to say, no, please don't bring Johnny in yet. Let's get this capacity evaluation first and see what it says. And the client will say, why don't you want to meet Johnny? I want to meet. I'd love to meet Johnny. I have the best clients in the world. But the second I sit down with Johnny, established attorney client, I'll have confidential information about Johnny. And if I have confidential information about Johnny, and keep in mind that is a term of art for the legal profession, I now know about Johnny in a setting or a situation where we're talking about representation, where that meeting is geared for me helping Johnny. If we later find out that Johnny doesn't have capacity and he can't move forward with the powers of attorney, we have to go to guardianship. Guardianship, by its nature, is an adversarial proceeding. I am old enough. I remember when the caption of the case used to be Mom and Dad versus Johnny. Now we've changed it in Virginia. It's in Ray Johnny, but that doesn't change the adversarial nature. So if mom and dad are litigating, that's what this is, for guardianship, I can't, in my good conscience, represent mom and dad in pursuit of this if I've met with Johnny with the intention of him hiring me, retaining me to be his advocate. Now, there are some exceptions of the law because there's exceptions for everything, where an attorney with that type of conflict can bring the guardianship proceeding in an emergency. 9 times out of 10, that doesn't apply. And the overarching premise, once you find your special needs attorney, is they are your ride or die. You want them with you for all of those questions that come up, from powers of attorney and guardianship to benefits to your special needs trust. And most families don't want their special needs attorney disqualified because of a conflict, which means you have to hands up and walk out of the room. So in that setting, if we're in the gray area, I want the capacity evaluation first. Then we can discern which path we're going to go on. And then I'm going to remind mom and dad, just because the doctor has said Johnny can do this, it doesn't mean I'm on board yet. I still got to talk to Johnny and make sure I feel confident that he understands what we're doing. That evaluation helps me, and it helps keep me from being disqualified to assist. So we talked about powers of attorney, the general protocols, procedures. Let's say that guardianship capacity evaluation comes back that Johnny can't understand what he's doing. Not what he's doing legally, for that legal definition of incapacity. Now, I was mentioning to Jan ahead of time, really important to note where guardianship comes in and where it's the devil and where it's not. We never want to run to guardianship, but sometimes we need it. If an individual doesn't have that legal ability to contract, to understand what's happening, to truly fulfill the concept of a power of attorney, where the authority flows through and out, because that authority is there in the first place, we need guardianship. We don't ever want to jump to it, but when we need it, we need it. So if we are on that side of the aisle, our procedure is going to be a little bit different. I, as the attorney, Jan, there goes the jaw. I, as the attorney, am never going to meet Johnny, the respondent, not until the proceeding is over, because I'm representing mom and dad in bringing this proceeding. It's formal, it's long, and it's not quick. Any county in the Northern Virginia area, best case scenario, we're talking between 3 and 4 months to obtain uncontested guardianship. It starts with hiring a lawyer. The lawyer is going to ask you to fill out a tremendous amount of paperwork. You'll get a doctor's evaluation. It's going to be way more intense than the one I've asked for to discern capacity. Get the evaluation, and we file in the county where the family lives. That's what's called your residency, your home. The county you live in is the county we petition in. Now, it's also really important to note with these, the court does not consider them an emergency. I tell families that I lose control of the proceeding as soon as we filed. Once we have all our ducks in a row, we have our capacity evaluation, the super long one. Counties have now started requiring additional paperwork to ensure there's no fraud, identity theft, that the respondent is in fact the respondent. And that's what Johnny's known as through the proceeding, the respondent. Once it's filed, we are at the mercy of the judicial system. We wait and we wait. And sometimes we wait a little bit longer for the appointment of a guardian ad litem. A guardian ad litem is an attorney who has a special certification, has taken classes in order to act as the eyes and ears of the court through a guardianship. They are not the respondent's attorney. The GAL is not Johnny's attorney. The GAL is the eyes and ears of the court. Now, it's important to note any attorney who takes these classes can become the GAL. So it may not be somebody who practices in this field routinely. It could be an attorney who's down on their luck and needs some court-sponsored work. That's particularly where we see delays. We recently had a case with a 4-month delay because the guardian ad litem was unaware of the process and protocols, and we as the petitioning attorney had to keep pushing the process through. The guardian ad litem will have paperwork. They will meet with Johnny. They will serve him with the paperwork as part of his due process rights. They will report to the court if Johnny needs a lawyer. And then if everything appears to be in order, we all appear in front of a judge on a Friday morning, and the judge enters a guardianship. The entry of that order is what removes legal capacity. What happened automatically upon turning 18 is taken away. And we can specifically outline what authorities can be kept and what authorities are lost. So the biggest are voting, driving, marrying, and firearms. All of those are related to the right to contract. And that brings us full circle. That's the capacity you need to have to do powers of attorney. If you don't have the ability to contract, presumably, or contract, presumably all of those authorities are taken away. Now, there are certain cases where we ask the judge to retain those authorities. Driving, voting, marrying are the biggest. And I warn families ahead of time, there's no guarantee we'll get it. And if you want more than one of those rights, our case is going to get even harder because the judge is going to respond, well, Mrs. Crane, you filed a petition that said Johnny doesn't have capacity. How is it that Johnny has the capacity to drive or vote or marry, but we still need guardianship? Because Virginia is a state that values personal rights and wants to be very, very sure that those personal rights are honored and respected. We start from the premise of capacity before removing it. So it's a hard case to make to keep one. I've never been able to keep two, not in recent time. When I was a baby lawyer, I started practicing when I was 23. We kept the right to vote for everybody, even elders who were in comas, because we didn't want to take it away. It's a right that a lot of people fought and died for. We wanted to keep it. And unfortunately, we are seeing a trend where courts are saying, no dice. It's capacity or not capacity. Now, we have had some luck recently keeping the right to vote, keeping the right to marry with guardian sign off. I've never successfully seen the right to carry a firearm, but it doesn't mean it's not there. It just means it's harder and harder because guardianship, just like our powers of attorney, have laws and statutes that change and evolve and grow. And courts in recent years have been told guardianships are being granted too easily, they're being rubber stamped. We need higher levels of evaluation. That makes the proceeding on this side all the harder to prove. And so we try to respond to it and we try to be as aware of it as possible. So I've been thrilled that in 2 cases we were able to maintain the right to marry. It's a big thing. And if somebody is in love and wants to be able to marry, we want to preserve that. But we also remember, I'm talking very sterilely about this concept of guardianship and capacity versus not capacity. Guardianship is a big, big deal. We stand up in a court, it's a public proceeding. Usually the judge calls us up to the bench, so at least the entire courtroom doesn't hear it. And we take away somebody's right. We turn them back into a minor child. It's a lot. And we don't want to do it unless we're absolutely sure that we need it. And it all gets back to that capacity and being honest about what our loved one can or can't do. One thing I do want to touch on briefly, we see changes and trends just like any other field of life. We're seeing more and more guardianships that necessitate mental health powers. And it's really important to advise your attorney if you think those might be necessary. So, for example, if we need the guardian to have authority to treat mental health conditions, psychotropic drugs, ECT, there's a lot of very big, very big and scary treatments. And the law sets a really high standard for granting them, as it should. We have to know as soon as possible so we can try to push through the granting of the power. What do I mean without all of the legalese? If your child is nonverbal autistic, is perhaps displaying signs of catatonia, perhaps displaying signs of sudden onset psychosis, which we're seeing more and more around age 18, 19. If we are in the process of getting guardianship, if we haven't gotten it yet, tell your lawyer immediately, because it changes how the proceeding moves forward and what powers we need to obtain. So if we have somebody who needs psychotropic medication and electric shock treatment, Virginia's code sets a much higher bar for a judge granting those. There has to be a different type of hearing with evidence and testimony offered in court, not the standard guardianship. If we know, though, when we're getting the standard guardianship, we need them, we can, I don't want to say roll it into one because that undermines the gravity of it, but we can make our most effective use of interactions with the judicial system. If we get the standard uncontested guardianship at age 18, and then we have to go back because of sudden onset psychosis and related treatment authorities, we're going through the same process again. And it's neither quick nor easy, which means there probably will be some TROs or TDOs in the interim. And those are tough. So when you're in the process of deciding 18 is coming, we don't know what to do, before you even start thinking about which path are we going to take, what does Johnny need the most, the very first thing to do is find an attorney that you trust to work with. You want to interview at least 3. If they won't talk to you for free for 15 to 20 minutes, you don't want them. Now, anything over that is probably not going to happen, but 15 to 20 minutes to chat through and make sure it's a good fit, because you're talking about incredibly intimate things that you may not want to talk to just any old person about. So finding the lawyer who can help you with that process is absolutely critical. It's absolutely critical, because otherwise, if that relationship and that rapport is not established, you're not going to be able to walk through this incredibly complex process. Now, we do generally have to pick one or the other. It's usually powers of attorney or guardianship. You'll notice I'm not talking about conservatorship. Conservatorship is the legal authority in Virginia to make financial decisions when somebody is incapacitated. Virginia breaks, if there's a legal incapacity finding, we break personal decisions and financial decisions into separate categories, guardianship and conservatorship. Very frequently, we aim to only have guardianship and not get both. Now, if we need conservatorship, we will, but we want to be very, very careful to only get it if we need it, just because the requirements surrounding it are so high. Lots of families will say, well, Jen, we might as well just get it while we're there. I feel my
Your sound is off, Jen.
Jan, can you hear me?
Now I can.
Okay, sorry, we're having major technical issues on my side and everything just died. The conservatorship authorities in Virginia are rigorous. So a lot of folks gravitate, remember I said powers of attorney are easier. It's within the confines of the attorney's office. There's no interaction with the judicial system.
Guardianship, not only are the processes to obtain it extended, afterwards there's monitoring. Because if the court is going to declare a legal decision maker, they need to make sure the legal decision maker is doing everything they're supposed to be doing. And they do that with paperwork, right? Because that's the most effective way, she said, laughing. With guardianship, there's annual reports. Now, those reports they're not, how do I say this politely? It's paperwork. I tell families to save it on their computers as a Word document that they can update. I will say that most counties are starting to crack down on families that are not filing their reports. And we're hearing that when we go to qualify new families as guardians. So, when we have that successful guardianship hearing where mom and dad are appointed as guardians, then we go to the probate office. You raise your right hand, swear to take care of your child, just as you've always done. You'll get a packet of reporting requirements. And we're hearing more and more that Department of Families is cracking down where they're not getting those reports. But the report isn't onerous. It's not that difficult to do. When there's conservatorship, which is the financial management, the reporting requirements are way more stringent, which is why we only want to get it when we absolutely need to. The IRS lets you round to the nearest dollar. Reporting requirements to the Commissioner of Accounts, who supervises the administration of conservatorships, those have to be done to the penny. So we really don't want to do it unless we absolutely, positively need it. So again, making sure we know what we need, what Johnny is capable of, all of that is crucial, because you can wind up getting the wrong type of proceeding that you didn't need and now is going to create an added burden. All parents know that the level of work required to take care of our children is not for the faint of heart. And when you add in the work required for a special needs child, it's daunting. It's absolutely daunting. And I tell families when they come in to meet with me, nobody ever has a baby or adopts a baby and says, man, I really want to work with a special needs attorney. So once you're here and we're doing the things we need to do, effectively tailoring it means not only is the documentation the best it can be, it also means we didn't inadvertently make more work for you. So doing all of that pre-planning is absolutely critical. And it starts with that concept of an honest assessment of where we're at. What can my child do? How can I best continue to serve my child? And which avenue will be best for the long term? Because if we can't understand the powers of attorney, we'll run into problem after problem after problem, and we won't be able to solve them. If we get guardianship and didn't need it, conversely, undoing it is really, really hard. When a court grants guardianship, it's saying, I've reviewed everything in the petition, the medical evaluation. I have decided that Johnny is legally incapacitated, and I therefore am executing my authority as a member of the judiciary for the Commonwealth to remove capacity. Well, if we want to undo guardianship, what do we have to do? We have to prove that the person is capacitated. Judges do not love reversing themselves. I know that comes as a galloping shock, but judges generally think they're right. So when we come back with a petition for restoration, we have to have a really good reason why we're telling the court, you know what, actually, we didn't need this. And saying, oops, we goofed the first time isn't enough. So I'll give you an example. Sometimes we can get a limited guardianship. So when we do limited, it means it is limited in duration or scope. We have an individual who is in a car accident and is subsequently in a coma. we would most likely get limited guardianship and conservatorship if a doctor were to be able to tell us Jimmy is likely to regain capacity in 6 to 8 months with the proper treatments, therapies, and rehab facility. Okay, that's a real good case for reversing or undoing guardianship. There's been a clear restoration of capacity. Getting it the first time around and saying we didn't know what we were doing or counsel didn't explain it, well, it still gets back to the judge, right? It's the judge who entered it. It's a much harder thing to undo, particularly if we've gotten guardianship where mental health is concerned. If we came before a court and said, Your Honor, my son Johnny is exhibiting signs of bipolar schizoaffective disorder. We have 6 or 7 attendant conditions. We are worried about a psychosis risk, and a judge grants it. If we want to undo it at a later date and time, we are going to have an uphill battle because the court's going to say, these are mental health conditions that will never go away. They can be properly treated. But when you petitioned the court, you told me it was so bad, mom, dad, and petitioning attorney, we had to go down this path, that we had no other options. Tell me why it's changed now and what guarantees we have that it's not going to recur. So it's critical we make the right decision before we get there, because it's not quick or easy to undo. Same holds true for conservatorship. If we get conservatorship, court-ordered financial decision maker, where we didn't need one, you still have to file the reports, even if there's nothing on there that would necessitate mandated reporting. You still have to do it. So because these reporting requirements are onerous, they're burdensome, they're necessary, but we don't want to get them if we don't need them. So we often talk about that toolkit concept. It's better to have it and not need it than need it and not have it. It does and it doesn't apply to what we're talking about here. With powers of attorney, for example, if Johnny comes in and the family says, well, we only want medical, we've decided financial's not worth it. We're going to have a long conversation about that one because you probably do need both in order to be an effective decision maker. But that concept doesn't hold true for guardianship and conservatorship. We almost always need guardianship, but we don't want to embark on conservatorship unless it's needed. And again, it gets back to the very initial concept of having those open and honest communications with the attorney to make sure they can tailor the proceeding. Oftentimes, families don't disclose information, and it's because they didn't feel comfortable sharing it. But we've got to let the attorney be the one to decide whether or not something's relevant. I'll tell families when they first come in to meet with me, throw the pot of spaghetti against the wall. Let me decide what sticks and don't stop talking. Please don't look it up in advance. Please don't try to find the correct terms. Just tell me the whole thing, and then I can help you sort out what portions are relevant and what portions we should focus our attention on most exclusively. So all of it gets back to, how do you find somebody to work with your family? How do you discern powers of attorney versus guardianship and conservatorship? How do we discern the bigger team that we're going to have at play? How do we discern who the people are to name? Because it doesn't matter which category we pick, whether we have powers of attorney or we have guardianship, we have to have backup decision makers. So if we're in power of attorney territory, Johnny has to name somebody to help him after mom and dad. Because just because Johnny has capacity now doesn't mean he'll have capacity in 20 years when mom and dad are gone. Same for any of us. No power of attorney should only have one agent. You want a deep bench. Johnny has to know who to name. And Johnny needs to talk to the agents to make sure they want to serve. Because we build the document not just for now, but for a long time. Same goes for guardianship. Now, guardianship is typically mom and dad who are appointed, and sometimes there'll be a standby appointed. What's standby? Exactly what it sounds like. If the guardians can't act for whatever reason, the standby can step up. But what I have found is not a lot of people who get guardianship and have a standby know that standby guardianship is good for 60 days. And then we need formal court action for the standby to step up. So what we have found logistically to make more sense is we mentioned to the family, look, I'll put it in if you want, but when the first parent dies, we need to really start thinking about petitioning the circuit court to name a neurotypical sibling as a co-guardian to serve with the remaining parent. So that way, when God forbid both mom and dad are gone, we've got a procedure already built where neurotypical sibling can just step into the role. These documents are only so good if we plan for their use. And a particularly forgotten concept is a lot of time this stuff is being activated during a period of stress or grief. If Johnny has just lost both of his parents, in the midst of this, do we really want to be sending a GAL out to serve him with process because we had to file a brand new guardianship proceeding? No. I mean, we will if we have to. Let's keep our eye on where it is. But we don't spend enough time in this field focusing on how Johnny is affected by everything. And so if we can take some preemptive action, thinking through backup powers of attorney, thinking through appointment of a co-guardian who's a neurotypical sibling, and we anticipate actuarially will be alive longer, we can make this process easier. All of those things, though, assume we've also talked to the neurotypical sibling to make sure they're on board with it and they understand what they're being asked to do, so it doesn't come as a galloping shock when they're named, because they would also be grieving the loss of a parent at the same time. And asking them to not only grieve that loss, but now step in as a decision maker is a lot. So there's so much planning we have to consider. And you're saying, Jen, this is crazy. Our child just turned 18 and you've already killed me off 40 years down the road. Well, that is why I am no fun at dinner parties, because I plan for people's death and disability. But I do plan for what's our long term. How can we best serve Johnny? How can we best serve your family? And we can do that with pre-planning. All of that starts, though, from the premise of Johnny is turning 18. What do we do? How do we know who to name? How do we know which documents to pick? You do need legal counsel to assist, but what you also need to do is educate yourself before going in. Now, anybody who knows me knows that Google is the bane of my existence. And that's because I have no idea what clients are going to find on Google. They could find Uncle Bob's blog that could have completely inaccurate information. My favorite is you can't get benefits if you have a special needs trust. That's everywhere on bad websites. If you want to educate yourself about these proceedings and have a frame of reference for when you contact a lawyer, I would strongly recommend the Special Needs Alliance website, the Academy of Special Needs Planners. All of that information is current. Tell your attorney, I want information. I want to be able to read about it. I want to be a partner in making the decisions. Respect that we have to, all parents are used to making decisions for our kids. We do it all the time because we can, and that's what's expected of us. But once we hit that magical age of 18, particularly if powers of attorney are involved, we have to see Johnny as a decision maker. We have to have him be autonomous in the process, because if he can't meet and interact with the lawyer, we're not going to know that these documents are his and they can't be yours. The guardianship proceeding is much different, right? Because it's that adversarial proceeding where there's a finding of legal incapacity. But again, we don't want to jump to it until we're sure that we need it. And if we need it, we have to be sure of the component parts we need: guardianship, conservatorship, any mental health authorities that are important and need to be considered. With guardianship, let's say we're squarely in that path. Let's say that you know for sure we're going to need it. Another question that comes up frequently is, what if we don't get it before age 18? What happens? Well, the first question I ask my families are there any providers in Johnny's life who are automatically going to exclude you from the room on the 18th birthday? And 9 times out of 10, the answer is no, because your child's providers have known you for just as long as they've known your child. There could be emergency medical situations, though, where that arises. And what I tell families is, I can't make the proceeding move any faster than it's moving, but what I can do is give you my card. And if there's a problem, have that provider call me, and I will explain to the provider that we are in process. Here's where the guardianship is as far as the court's concerned. We're waiting for appointment of the guardian ad litem, yada, yada. You know, it's not that you absolutely have to have it at age 18. That's the goal. But even when we can't obtain it by that date, because again, your lawyer is going to lose control of the process as soon as the petition's filed. We can't make it go any faster. We can still be there as an advocate to help explain to third parties what's happening. You know, we recently had a super unpleasant one where the guardian ad litem lists exist at each circuit court. And so when a guardianship proceeding is filed, the clerk of the court, depending on whatever protocol each county sets, largely just pulls a name. And there are indigent petitions and paid petitions. What do I mean by that? Well, if somebody has no resources, it's a guardianship petition and the respondent has no money, because most 18-year-olds don't, the guardian ad litem is paid by the Commonwealth of Virginia. They get paid $55 an hour for outside of court work, $75 an hour for in-court work. You can imagine not a lot of people love getting those indigent guardian ad litem petitions. And again, oftentimes we get lawyers who are down on their luck and they're taking this because it's regular work. We can't make that guardian ad litem go any faster. So we had a case where the guardian ad litem was appointed and did nothing for, I think, 2 or 3 months. And we kept prodding and prodding and prodding. And for whatever reason, you know, we keep getting blowback. The family says, can we get them replaced? And I said, we can, but here's how much it's going to cost for us to go into court and get the guardian ad litem removed. And the family generally doesn't want to pay that fee. It's hard once we get to that part of the process because we can't control it. So we generally just try to roll through it. But again, it causes delays. And in that case, because the family had very diligently started right on time, process is moving forward, we hit this roadblock. Family knows, have those third-party providers call me. So if there's a problem, I can explain where we are. But no matter how well-intentioned, we can't always make the timing work precisely. Flip side of that coin is your powers of attorney. I can't start the stuff until the child's 18. Because they're legally incapacitated prior to that date. So again, each side has their limitations. Another really important thing that, you know, we talk about the capacity, we get to the documents, we know what they do, what they don't do. Guardianship and conservatorship is ironclad. It's the order of the court. It has to be accepted. Powers of attorney are permissive, not mandatory. So if I have a power of attorney document and I give my husband that authority, right? He's my agent. I can revoke it at any time. Virginia law makes that real easy for me to do. And remember, powers of attorney have a presumption of capacity. So if Johnny names me as his agent, Johnny can fire me as his agent at any time. Even if, say, Johnny is going through a mental health crisis, there can still be the presumption of capacity at the time the power of attorney is revoked. So powers of attorney allow you to work in lockstep for your child, but they don't allow you to overrule your child. It's another huge distinction as between them. Permissive, not mandatory, absolutely positively mandatory. They both have pros and cons. There is not one right choice for everybody. There is a right choice for your child. And the only way to figure out what that choice is to honestly and accurately assess the situation, pull in providers that you trust, pull in people who have always been there in your inner circle and talk to them. You know, sometimes talking to family members who have been through it is helpful. Sometimes it's not, because not every situation is the same. We'll have family members who will file the guardianship petition themselves after having found another relative who did it. They'll just take the petition, change the names, and file on their own. Well, you can certainly do that. There's legally nothing wrong with it. But if we haven't walked through the steps ahead of time to make sure we need guardianship, you may be at the wrong stopping. That mandatoriness of guardianship can be really attractive, particularly because we've removed the right to contract. And removing that right to contract means that if your child or loved one is particularly susceptible or vulnerable to fraud or abuse, we don't have to worry about somebody conning them into taking out a credit card application or a loan application. We can squash it as void ab initio, void from the outset because they didn't have capacity. But that's not the only reason to do it. The powers that come with it comes great responsibility. And if it's not the right tool for your child, because your child is capacitated, they can understand these documents and what they do, that has to be given credence as well. No situation is going to have, or no case is going to have the same resolution on each side. Every situation is going to be different. Every guardianship proceeding is going to be different as between the counties, how they handle things. Reporting requirements are going to be different. The one thing that will be the same is how your capacity toolkit transfers if you move. If you move, you're going to have to get updates in the state where you're going to. You know, for example, with powers of attorney, your documents are considered valid where executed, valid everywhere. But if you move to the new state, if you can get new powers of attorney, you should do it. It's always easier to use documents that are recognized in the state versus having to force ones from another state. Remember at the very beginning, we said powers of attorney are hard to use to begin with. Try using out-of-state documents. It's even harder. With guardianship, we do have to get it transferred. Now, there is something called the Uniform Guardianship Act. And for states who have accepted it, it in theory makes the process a little bit simpler. It's still complicated and takes a long time. So basically what happens is we have to get the other state to provisionally cede authority to Virginia. Virginia will accept, I mean, it's like lobbing a tennis ball back and forth between the two states to eventually get it transferred over here. The good thing is we don't have to do a new finding of incapacity, but the bad news is there is just as much procedural hiccup as there was before. Unfortunately, there's a common misconception that the transfer is automatic. It's not. There's at least 2, if not 3 proceedings necessary on each side. Typically, we open a proceeding here, lawyer in the other state files a proceeding to have it moved. The authority is provisionally ceded to us till we accept it, at which point it's canceled in the other state. They're all complex processes, but whichever one you pick, we want to make sure it's the right one for your family. And we want to make sure we're honest about how we got there in the assessment for where we need to be. Because that answer is going to change. That answer isn't the same universally. And it's just so important that we meet everybody where they are at and we do what they need done. I think the landscape will continue to change, in particular to the mental health powers, as we see that become more and more of a pressing concern, but we adapt to them at the time. Your capacity toolkit, as you can see, is deep and wide and broad. There's a lot of different options. I know at least one person must be asking, can't we pull from each side? Is it possible to have a medical power of attorney and a conservatorship? Absolutely, but that's not typically the course of what we're talking about today. Very, very briefly, I just want to mention educational powers of attorney are also crucially important. And just as important is making sure we do financial and medical powers of attorney in tandem and not just doing one versus the others. Eleanor and Jan, I see we have some questions. Would it be okay if we start tackling those?
Yes, so if you click on the Q&A, you'll be able to read the questions and see them. Please keep a note, our audience doesn't see the questions, so you'd have to read them
Sure.
out loud so they know what you're answering.
Absolutely. Thank you, Eleanor. So the first question says, our son is 21 and we were able to secure legal guardianship. Why would I need power of attorney?